Wait till Neil comes in. Have you seen anything? Have you seen anything? Which one would this one?
It's a retired Judge Nick Henderson.
Did they not take some off? See.
Okay, I forgot all that. That's all right. See, I'm just not. First week back, my brother's gone dead.
That's right.
He's got his laptop to plug in.
No. I guess Neil's probably going to get that. I don't know if Neil got the email.
Well, I'm sorry, you've had to wait longer than I led you to expect. But we are in a position to give our judgments. I will give the first judgment. The appellant is a national of India, now aged 33. He first came to this country on the 19th of September 2011 on a student visa, and in June 2013 he was granted a Tier 1 entrepreneur visa. His immigration history thereafter is a little complicated, but what matters for present purposes is that on the 13th of January 2020, the Secretary of State refused an application by him for further leave to remain on suitability grounds. What she alleged was that for the purpose of the application for the entrepreneur visa, which was eventually granted in 2013, he had submitted a certificate of proficiency in English, the so-called TOEIC certificate, which he had obtained by having the oral part of the test taken for him by a proxy. The test was administered by Educational Testing Services, ETS, and taken by the appellant at New London College, NLC, on the 18th of July 2012. The appellant appealed against that decision. His appeal was initially dismissed by the first tier tribunal, to which I'll refer as the FTT. On appeal to the upper tribunal, to which I'll refer as the UT, the decision of the FTT was set aside, and it was directed that the decision should be remade following a de novo hearing before the UT itself. On the 21st of July 2022, Upper Tribunal Judge O'Callaghan dismissed the appeal. On the 19th of August 2022, he refused permission to appeal. On the 27th of March 2023, Lord Justice Snowden granted permission to appeal on two grounds, which he summarised as follows. One, that the UT placed excessive reliance on the decision and findings in DK and RK, 2022 UK UT 00112 brackets IAC. The UT was wrong and did not give sufficient reasons for its conclusion that the entirety of the tests taken on 18 July 2012 at the New London College were fraudulent, and the UT did not properly analyse the appellant's written and oral evidence that he had personally taken his test or give reasons for rejecting that evidence. And two, that the UT did not properly take into account the evidence as to the appellant's proficiency in English as evidenced by his IELTS certificate from 2009 and his proficiency in English at the UT hearing in 2022. Lord Justice Snowden accepted that ground one had a realistic prospect of success. He doubted whether the same was true of ground two, but he granted permission on it so that the case could be considered in the round. The appellant has been represented before us by Mr. Sushil Belara of Council, who also appeared for him in the UT and indeed the FTT. The Secretary of State has been represented by Mr. Colin Toman of Council, although in the UT she was represented by a senior presenting officer. I need not recapitulate the history of the TOIEC litigation, which has generated a great deal of case law. The correct approach for a tribunal which has to determine whether an applicant for leave to remain used a proxy in the spoken English part of the ETS test was most recently set out by a panel of the upper tribunal comprising the President, Mr. Justice Lane, and the Vice President, Mr. Mark Ockleton, in DK and RK, the Secretary of State for the Home Department, 2022 UK UT 00121 to IAC. It carried out a careful review of the evidence about both the reliability of the method by which ETS determined particular results to be invalid, and of its system for matching results to individual candidates, the so-called chain of custody. It also noted the evidence that some ETS test centres were, quotes, fraud factories, close quotes, where organised cheating was widespread, if not universal. One of those centres was NLC, where the appellant took his test. The organisers at NLC had been prosecuted for conspiracy to facilitate breaches of immigration law, and the UT quotes extensively from the judge's sentencing remarks. At paragraphs 119 to 125 of its reasons, the panel examined what it called two strands in the evidence about such fraud factories. At paras 126 to 129, under the heading General Conclusions, it said, well, I was not, in fact, in any event, going to read out those paragraphs, but was going to ask for them to be read, to be inserted in this judgment when transcribed. Turning to the present case, as in all cases of this kind, the Secretary of State's case in the UT that the appellant had cheated in taking the TOEIC test was based partly on the evidence of the ETS audit result and lookup tool, but also on the fact that NLC was established in DK and RK to have been a fraud factory. More particularly, the evidence showed that in 12 of the 16 cases, 12 of the 16 spoken English tests taken at NLC on 18 July 2012, including the appellant's, a proxy had been used, with the tests in the remaining 4 cases being, quotes, questionable, close quotes. Likewise, over the period between March 2012 and May 2013, 74% of TOEIC speaking and writing tests were found to be invalid, with the remainder being questionable. The presenting officer also submitted that the appellant's failure to ask ETS for a copy of the tape of his test was indicative of guilt, but to anticipate, that was a matter to which the judge said he did not intend to attach weight in his decision. The appellant's evidence in rebuttal consisted of a witness statement initially prepared for the FTT hearing but used again in the UT, in which he asserted in terms that he took every component of the test himself, and that he was deeply aggrieved and upset by the allegation that he had cheated. He said that he had no motive to cheat because his level of spoken English was always at a very good level, referring, among other things, to the fact that he had been educated in English in India, and that he had had to demonstrate proficiency in English when he applied for his student visa. He also referred to the fact that he had to use English in his business, but that, of course, the business which had not been started until he, at the time that he took his test, because it was dependent on the grant of his visa. He gave oral evidence in the UT, confirming the contents of his statement, and was cross-examined by the presenting officer. We have been supplied with the appellant solicitor's note of his evidence, which Mr. Toman confirmed was agreed as far as it went, though it is by no means a perfect note. Though it is by no means a perfect note, it is sufficient to make the points which Mr. Bellara sought to draw from it. The note shows that he amplified his witness statement to a limited extent, among other things by referring to the test which he used in for the purpose of his initial application for admission as a student, which was a so-called IELTS test taken in 2009. On that test, he scored 5.5, which corresponds, to quote from the official note, to what is described as being a modest user who, quotes, has partial command of the language, coping with overall meaning in most situations, though is likely to make many mistakes, should be able to hand basic communication in his own field. The judge, in his reasons, gave a full and careful summary of both parties' evidence at paragraphs 14 to 18 and 19 to 27, respectively, and of their submissions at paragraphs 28 to 35. His analysis and conclusions appear at paragraphs 36 to 45. He begins by referring to the approach to the burden of proof established in DK and RK. In that connection, he notes that Mr. Bellara conceded that the Secretary of State had a strong prima facie case. That concession was in truth inevitable in view of the passage from the judgment in DK and RK, which I have already quoted. The judge then goes on at paragraph 37 to say, and again, I am not going to take time reading this out, the whole of paragraph 37 of the judgment, which deals with the IELTS certificate and its relevance, is to be found, it should be transcribed into the judgment. At paragraphs 38 to 41, the judge summarizes in very broad terms the background to the TOIEC cases and the conclusions in DK and RK. At para 42, he summarizes the evidence against the evidence supporting the Secretary of State's case that the appellant was guilty of fraud, namely both the result of the ETS audit in his own case and the pattern of cheating at NLC. He continues at paras 42 to 45 as follows. And again, I will not read out those paragraphs, but they should be transcribed in full into the judgment. I have already quoted the grounds on which Lord Justice Snowden gave permission to appeal. As developed by Mr. Bellara in his Stellarton argument, and more particularly in his oral submissions before us, ground one can be summarised as follows. It is clear from paragraph 127 in particular of the judgment in DK and RK that the strong prima facie case established by the generic evidence can be rebutted by, quotes, credible evidence, close quotes, adduced by the applicant. The appellant in this case had given clear and explicit evidence, both in his witness statement and, more importantly, in his oral evidence, asserting that he had taken the test himself. That evidence had been consistent, both in the original hearing in the FTT and in the UT, and had not been shaken in cross-examination. That being so, the judge had not, in his reasons, addressed that reasoning with any specificity, or said, not addressed that evidence with any specificity, or said why he rejected it. In the absence of reasons for rejecting it, the judge should in fact have found that it was sufficient to discharge the evidential burden of proof resulting from the generic evidence, or, even if that were not the case, the appeal should still be allowed for inadequacy of reasons. I cannot accept that submission, which does not fairly reflect the approach taken by the judge. He was entitled to, and did, take as his starting point in para 42, both the fact that the appellant's result was found to be invalid by ETS, that is on the basis that the voice was that of a proxy, and the fact that NLC was an established fraud factory. Those findings, as the UT makes clear in DK and RK, make it not only probable, but highly probable that he had in fact cheated. He was nevertheless obliged to consider the appellant's evidence to the contrary. He recognised that and considered it fully at paragraph 43, focusing on the main point which had been made before him by Mr. Bellara relating to the standard of the appellant's English. But it is one thing to say that it had to be considered. It is another to say that the evidence was obliged to be accepted. It was the judge's task to decide whether the appellant's evidence outweighed the effect of the generic evidence. And the message of DK and RK is that a mere denial is very unlikely to do so. Mr. Bellara says that the appellant's evidence amounted to more than a mere denial. But except in the most literal sense, I cannot accept that. It is true that the appellant adds a few details to his account of having taken the test himself, namely principally about how he chose NLC as the college to take his test, how he travelled there, and the numbers of people present and the like. He also, a point to which I will return, gives evidence about his proficiency in English. But none of that very limited amplification of the bare assertion that he took the test was capable seriously of casting doubt on the reliability of the results. the fact that the oral evidence was given consistently and with apparent conviction, and thus was in isolation credible, is not enough. The question for the judge was whether it was sufficient to discharge the evidential burden of proof created by the generic evidence, and he was fully entitled to reach the conclusion that it did not. As regards the evidence about the appellant's standard of English at the time that he took the test, which is the subject of round 2, I can see nothing wrong with the judge's reasoning in paragraph 43, and certainly nothing amounting to an error of law with which the court could interfere. Mr. Bellara effectively acknowledged that this was very much a secondary point in his grounds of appeal, as Lord Justice Snowden had already observed. One other point, which was initially relied on by Mr. Bellara, was that there was no evidence to support the judge's finding at the end of paragraph 44 that all the tests taken at the NLC on 18 July 2012 were fraudulent. It's not clear to me that by the end of his oral submissions, Mr. Bellara was persisting in this point, but in any event, I do not accept it. It was a finding which the judge was fully entitled to make on the basis of the evidence that 12 out of the 16 results were invalid and the remaining 4 were questionable. Finally, and very much as a footnote, I should note that Mr. Toman drew attention to what he said was a typographical error in paragraph 100 of the judgment in DK and RK, where the figure of 80 in the 8th line of the paragraph should, he says, be 18. The the paragraph in question relates to Mr. Toman's own cross-examination in that case, so he is in a good position to help on this. I am only making this point because at an earlier stage of his submissions, Mr. Bellara had sought to, in his written submissions, Mr. Bellara had sought to make a point about the difference between the numbers being tested in RK's case and the numbers in the present case, though that was not in fact a point that he adopted in his oral submissions. I find it hard to see how it could be relevant in another case, but out of abundance of caution, I am happy to recall what Mr. Toman told us. For those reasons, I would dismiss this appeal.
I agree. It seems to me that the judge dealt fully and fairly with the evidence, as my lord has said, and that any attempt by this court to go behind that evidence would be contrary to principle. See in particular paragraphs 114 to 115 of Fage against Chobani, 2014 EWCA Civ 5, and Volpe Delta Volpe, 2002 EWCA Civ 464, in particular paragraph 2.
I agree with both judgments.
Well, I'm grateful. There is an application for the costs at the Court of Appeal stage on behalf of the Secretary of State. I do not have a schedule with me, but I'd invite the court to make the order to be assessed.
Why don't you have a schedule with you? It's said standard practice for, in a case which is listed for less than a day, to submit a schedule of costs before the hearing.
My lord, I accept that. The expectation was that the judgment would be reserved.
Well, in the first case, that's not a safe expectation.
Yes.
And secondly, that the obligation that exists whether the judgment is going to be reserved or not.
My lord, I'm in your hands on that.
Well, in principle, do you have anything to say about, first of all, about the principle of whether you should pay costs?
My lord, my instructions are to oppose the application for costs. That my solicitors have not been put on notice that there would be any application. No schedule has been served, and in essence,
Well, the first point is, if I misread, a bad point. Solicitors should certainly have anticipated that if they lost, there would be an application for costs, and that would cost order would normally follow unless there was some very special reason why you wanted to argue to the contrary.
I'm in your lordship's hand in relation to this.
Well, subject to anything my lords may say, I don't think there's very much need to be said about the question of cost. The only question is whether we should order an assessment, which seems rather over the top in a case of this kind, or whether we should do a summary assessment, in which case there would have to be provision for exchange of, well, not exchange, but for you to see what costs were being sought.
Yes. Can I just take a moment to ask my solicitors what?
You can, yes.
April?
Well, Mr. McGuire, have a quick word. Anything you want to say, Mr. Toman? We'll just decide how we propose to proceed, and if it's anything that's adverse to you, we'll give you the chance to say anything more about it.
Yes, I mean, at the risk of being over-optimistic on this, I'm usually accused on the Secretary of State side of understating costs or under-exaggerating costs at this end. So if the court were to order a detailed assessment, it would be very unlikely that there would be a material contest between the parties.
Very unlikely there would be, but yeah. Well, I think we're aware of the reality of this. It is entirely the case that, as you probably know, to your
Personal detriment.
or if I can't remember right, the word is that the Secretary of State is not generous in the fees he pays to counsel, and that's where the bulk of the costs will be.
I just want to see if he was taking instructions.
Oh yes, thank you. Did you have anything to say, Mr. Bernard?
Yes, my lord, very briefly. My instructing solicitors have just asked for there to be some exchange between the parties in relation to costs. There hasn't been any window or scope for that as of yet. So, in terms of fairness to the...
Well, it may. Oh, certainly. So I don't think that you can be sure that we will not be making an order for a specific sum today. You may well anticipate there will be an order for costs. The real question is how that to be quantified.
Yes.
But rather than have an undignified huddle, we'll just go out for a moment or two.
Grateful.
Note to myself for next time.
All rise.
Mr. Bellara, we can see no basis on which the Secretary of State should not be entitled to her costs on the standard basis, but obviously we can't quantify them today. It seems the only sensible course is to defer any order as to costs on the basis that the Secretary of State will, within 7 days, and hopefully sooner than that, serve on your solicitor a summary statement of costs such as should have been provided in advance of the hearing. The likelihood must be, and our expectation is, that the parties will be able to agree costs, partly for the reason that Mr. Tobin has given. If that is not possible, perhaps I think we could put some deadline on that. I think the parties should, within 21 days, file either the terms of an order for costs or written submissions setting out their differences.
Yes, ma'am.
As I say, that is very unlikely to be necessary. If it is, and therefore further work has to be done, which probably wouldn't have had to be done if the summary statement had been lodged beforehand, that may be reflected in the amount of the eventual assessment.
My lords, I'm very grateful.
We'll of course deal with it on the papers if it happens.
Great, my lord.
Thank you both.
Oh, hi.